sorry about the gavel, but Metro TV wants me to use it, so they know we're coming back into order. I'd like to call this regular board meeting back to order from executive session, and today is Tuesday, September 15th, 2015, for the record. And we are down to item 14A, the third reading of Ordinance 1318, the matter of amending the Eugene Springfield Metropolitan Area General Plan and Metro Plan consistent with Policy G3 and Chapter 3, Section 2, Public Facilities and Services Element, amending Table 6, Table 8, and Table 18, and Map 3 and Map 4 of the Public Facilities and Services Plan to update the project list and map specific locations of planned public facilities in Glenwood and adopting savings and severability clauses.
I wasn't listening.
Those planners and their long titles. Anyways, thank you, Chair Bozovich, and good afternoon, Commissioners. The City of Springfield has initiated a series of changes to the Metro Plan, Public Facilities and Services Plan, primarily to coordinate future growth in the area of Glenwood, which is predicated on the new Glenwood Refinement Plan. Just a quick bit of background on this item. The Board and the Springfield City Council held a public hearing back on July 14th. At that time, it was requested that the record be left open. It was left open until August 14th. During that time, no new substantive information was entered into the record. The Springfield City Council held their deliberations on this item last week on the 8th, last Tuesday. They voted unanimously to adopt the ordinance. The Board has before them Ordinance 1318, which is substantively identical to the City's ordinance, and at this time staff is recommending Board approval. With me is Mark Metzger, who's the City staff planner on this item, if there's any questions for the Board. And with that, I'll thank you.
Questions for staff? Seeing none. So I guess the folks that were questioning some of the existing facilities that are shown on the maps got their questions answered.
Exactly, that's correct. Yeah, that was, and just to be clear, there was one additional question or email that came in during the open record period, and they were just trying to clarify what those sites were that were discussed during the public hearing and whether or not there were any new proposed site. And Springfield staff did a good job responding and explaining that those sites down near CV Loop, which were across the highway, and the LCC basin were not being amended with this proposal.
They're pre-existing identified sites for EWEB substation. Correct. I remember the map, but yeah, it was confusing to some of those people. They thought they were added new sites, and we got that explained well. Thank you. So if there's no further questions for staff, I'll entertain a motion. Commissioner Stewart.
Mr. Chair, I'd like to move to Ordinance 13.
Second.
We move in second. Any discussions of the motion? Commissioner Likens.
Thank you, Mr. Chair. First of all, I just want to say thank you to City of Springfield staff, particularly Mark. Mark and I go back a few years, and my prior work as mayor of the City of Springfield, and being involved in this in the very beginning, I really want to say this. I think what's transpiring here is very positive. And I think there's some real great, I think we always said there's some great potential in Glenwood. And so I want to say thank you to that, and to our staff as well. Thank you for working with the City of Springfield and getting those questions answered, because I think at a joint meeting we did clearly hear there was some really, I was almost surprised on how the misinformation was. And so thank you for answering those questions so we can move forward. But this is something I strongly support. It's making sure we get this key infrastructure in place as time goes on, so Glenwood then really becomes a real potential to market out there for future opportunities. So, great job.
Commissioner Stewart, I would like to really appreciate the time that it took to explain to the individuals that had concerns. I know I think a lot of the concerns were also kind of tied into the CV Loop area, as you explained, and I would imagine now after last night's direction by staff that folks will probably
further discussion to the motion? This is an ordinance, so I'll call for the roll.
Commissioner Sorensen?
Aye.
Commissioner Stewart? Aye. Commissioner Whiting?
Aye.
Commissioner Farr?
Aye.
Commissioner Bozick?
Aye. Motion passes unanimously. Thank you very much.
I was a city councilor. City council better than that.
I couldn't believe they did that either. How did you went with Right, we'll move on to item 14B, which is a work session discussion direction, land use implications of implementing marijuana regulations. And first I'll call on our administrator for a few comments.
Thank you, Mr. Chair, Commissioners. I'll just remind the board that you will recall a couple weeks ago, you heard a legislative update from Mr. Kyler and Ms. Chinsky, and talked in detail about the legislation, Measure 91, and the legislation passed in the last session by the state. We reviewed the current federal law, the state legislation that was passed in this session, the 4 types of commercial licenses regulated by OLCC for producers, processors, wholesalers, retailers, the personal allowance limits. We talked about the state taxation framework, early sales by medical marijuana dispensaries. We looked at new residency requirements for new licensees. We discussed briefly the local tax option, the local option to prohibit marijuana activities. We touched on the land use code, the land use compatibility statement that's required from local jurisdictions, and then talked about local time, place, and manner regulations. So all of that was talked about. Ms. Chinsky is available. She's not here, but is available today if you have questions related to those topics. But, we wanted to bring forward to you today a specific conversation, and a rather in-depth conversation, I think, related to land use implications in particular. So that's the focus of our conversation here today. Again, we can answer questions about those other issues, but our hope was to focus on the land use implications.
Great. Thank you, Chair and Commissioners. Good afternoon. I'm hoping to end your meeting today on more of a high note, so we can talk about House Bill 34 and as the Administrator indicated, focusing on House Bill 3400, there are 4 new proposed OLCC license types, and on the slides I provided you today as well. I'm just going to walk through this quick PowerPoint that kind of outlines the memo that you received in your packet. So the 4 license types: producer, which is the growers, processors, wholesalers, and retailers. And just to jump back to the administrative rules of how to implement House Bill 3400 are still being written. So we don't know what's going to come out of that rulemaking process, what rules the OLCC may put in place for regulating these uses, and also then how that may overlap with any local regulations that could also be put in place. So these 4 new recreational types of licenses are in addition to 3. Some places you read just 2 medical marijuana registration types, which are not licenses and are not under OLCC, but are registration types for the growing of medical marijuana, the processing, and then the dispensary of it, which are in place now. I want to make clear, too, that none of the land use components that we're discussing regulate or have anything to do with the personal grow or possession requirements or limits. So that isn't included in anything we're talking about. So, from a rural perspective on what the county regulates with land use and the unincorporated lands, the state and the House bill made it clear that retail marijuana production is a farm crop. It is considered a farm use, just like any other crop or farm use. However, they have specified a few particular things that make it different, and that is, 1, they're not going to allow a new farm dwelling to be qualified under the income test that's typical in state law for EFU lands, farm land, to qualify a new dwelling with production of recreational marijuana as a crop. And then the others are not allowing a farm stand. And third one, I'm not sure I listed on here, but the ones that commercial use and thank you. The commercial use related to the marijuana grow. So it would qualify for a tax deferral for growing that crop for farmland. So farmland could also be in farm deferral for that, and other protections related to Oregon resident farmland.
Mark, so is there a reason why they didn't allow the dwelling component to it? The reason that we've had dwellings in the past in conjunction with farm or forest is because you're going to be on site with neighborhood manage and to partake easier with this. It seems to me that this type of a problem, don't know anything about raising it myself personally, but it seems to me like you would want to have that component of somebody who's living there and taking care of it. So did they give a reason why the state wouldn't allow a dwelling?
So my understanding is the concern with, so the limit today is primarily you produce $80,000 worth of gross income off of farmland, and you can qualify for a dwelling. That's for either 3 years, or 2 years in a row, or 3 out of the last 5 years, you gross $80,000 from the crop. To be able to meet that $80,000 limit from marijuana could be done in basically a 10-foot by 10-foot shed. And so the concern was they're going to take a lot of farmland and qualify it for a bunch of houses, and that would really be the business people would be in at that point. I didn't follow the legislation and the committee meetings really closely, but that was my understanding of the fear behind allowing dwellings, is that there's going to start popping up new dwellings, farm dwellings, all over the place on otherwise farm ground that haven't been able to be qualified.
Because of all the other crop.
Correct.
So about me, is that sorry that we talking about two separate ones?
Commercial land is completely different. I can't even speak to that today, but I know it's just completely different. So that was my understanding of the reason.
That would grow a lot of commercial hemp to the 80,000.
But still, it's recognized as an agricultural crop, different from marijuana.
So that holds for the 80,000.
The 80,000 income would apply to the hemp. So I think in large part marijuana is a cash crop. You can qualify for 80,000 on a relatively small area, like Mark said. The traditional agriculture that the state law is built around is recognizing it takes larger parcels to end up moving those income accounts to qualify for a dwelling. They didn't want to give the farm away, so to speak, to just a cash crop and allow those dwellings to be so easily cited.
I think your question gets at some of the reason we're coming to you is some of the concerns we have with potential conflicts and with a caretaker, say, living on site of an operation. These types of uses being allowed as home occupations and those types of things. We're internally the land management are been sorting through some of those scenarios and coming to you asking for some direction on where we feel we should try and pursue that or not. Just to kind of go through the last half of the slides here, the House bill language is 111 pages long. Just a small portion of that relates to land use, primarily a few sections. Within the land use section of the bill language, there is a requirement that when OLCC is going to issue a new license, one of the 4 new recreational marijuana license types, they would come to the county to sign off what we often call a LUX, a land use compatibility statement, where we sign off authorizing or not whether that use that they're proposing and the license type is an allowed use on whatever property they're proposing to use on. So we look at the zoning and stuff at that point. There's a matrix at the very back of your pack today, attachment C, that kind of outlines not in the PowerPoint, but in the packet itself, that outlines our current language and how we think, if we did nothing, how the uses of the 4 license types may be allowed under our current zoning layout. So that's the way we see we would implement it if we did nothing today. And we can talk more about that. The House bill language, I went over some of this. There's some discretionary language in the House bill that says counties may regulate the growing of marijuana crops on other zone properties similar to EFU and forest zones. So we have other zones. We have rural residential zones, we have rural commercial, rural industrial primarily, and then we have the forest zone. So today we allow as an outright permitted use, as an example, farm use in the forest zone. So it's not differentiated between farm and forest for the most part. So whether we're talking strictly farm or forest on property, the growing of marijuana would be outright permitted. The discretionary language also allows in the House bill the local jurisdiction to enact what they refer to as reasonable regulations, as the administrator referred to as time, place, and manner regulations. I've just briefly kind of thrown out some ideas of what those might be based on some other jurisdictions, what other jurisdictions and counties are talking about in terms of potential time, place, and manner regulations. It could include hours of operation. It could include additional separation distance requirements from licensed facilities, prohibiting certain license types in certain zones altogether. We could regulate lighting, access control, security, screening, other potential impacts of surrounding properties, those types of things. One jurisdiction I recently read, I think it's up in the Portland metro area, but our county is considering requiring charcoal filters on ventilation systems for grow operations in rural residential zones due to concerns about potential smell and odor impacts from those growing operations. And then also looking at should any of these certain license types be required to have a special use permit to be allowed in certain zones. So those are just some ideas and what other people are considering, just food for thought there. And then lastly, really what we're coming to the board for, I kind of specified in 3 different questions, but first of all, should we spend our time on looking at trying to come up with some reasonable regulations for certain ones of these uses based on anticipated or potential impacts that we might foresee. The separation requirement, we could get into more detail on that, but under the current law for medical dispensaries, there's a 1,000-foot separation between medical marijuana dispensaries. There's also a separation requirement between those dispensaries from schools. Under the retail or recreational marijuana, there's not a separation required from a new recreational retail outlet from existing medical marijuana dispensaries, so they essentially go right next door. And there's no other separation requirements in the bill language from, say, having 2 recreational marijuana retail facilities right next to each other as well. So those, they leave up to the local jurisdiction as well, whether they want to look at separation requirements for the recreational license types. And lastly, it's a little bit of a complex issue, but it came to mind that certain city jurisdictions, and I'll use Junction City and now Coburg as examples. Junction City is a better example, but so there's their urban growth boundary, and then within their urban growth boundary, there's their city limits. The land between their city limits and their urban growth boundary is still under our zoning jurisdiction, under our Chapter 10 zoning. This Junction City has voted to send to their electors the question of whether they should prohibit the license types in their city or not. So in theory, they could prohibit it in their city limits, but we could still be allowing it right next door inside their urban growth boundary. on zoning. And a good example in Ring City is a rural commercial zone right next to a commercial zone property that's in their city limits. There's literally a line right between them. One could allow it, one could not. Whether you would see or direct us to look at potential for addressing those impacts or uses being allowed inside urban growth boundaries of cities that have indicated they might want to prohibit or deal with those differently.
So, just a legal question about that. Wouldn't we have to actually have a vote of the people inside the UGB but outside the city limits to do a prohibition or ban? And did we have enough of a negative vote to be qualified to have that kind of vote? I thought there was some set conditions on when you can have that kind of vote and when you can't. And I don't remember it being described as UGB areas. It was either municipalities or the entire external counties.
UGB areas don't have a council.
Yeah.
They're represented by us.
Right. But I don't know if we can split it down to that. We couldn't have where outside the UGB we're allowing facilities. Inside there has to either be the vote of people or a vote of us saying we're going to ban facilities in that area to match the city's ban. I don't know if we legally can even do that.
I don't think so. I think it's an all or nothing proposition for the jurisdiction, be it the city or the county. The city's vote, and it has to go to a vote, and we're talking about prohibition entirely, rather than regulation of time, place, and matter.
Right. This is a different story.
Right.
Prohibition, which is what the city council jumped in city referred.
Right. And so I think if the county could, and I can't remember, I think you were right, that we may not be able to have the vote anyway because of how the electors voted in the adoption of the measure, but I haven't looked at that specifically. But if we could, if the county could and did have the vote, I think it would apply to all land of the county, which is
Unincorporated.
Yeah, anything that's not incorporated. And conceivably, that even means within the UGB area of both Eugene and Springfield, with whom we have urban transition agreements. They apply their zoning code within that urbanizable land. But I see this vote that the city could undertake as more of a moratorium rather than land use regulations. So I don't know that vote could extend beyond incorporated boundaries of the cities with whom we have agreements. So I think my guess with respect to Junction City and Coleridge, I think this board's authority is probably going to begin and end with sort of reasonable regulation of manner and time.
But we won't be able to do a prohibition to match the city's prohibition. So the RC property that's just outside of city limits is not going to be, we won't have the ability to prohibit the retail sales establishment on that RC property, even though the city's commercial property just over the line may have the prohibition if the citizens move their moratorium.
If I could just say, the only thought I have on that in terms of time, place, and manner regulation would be the place being, that's a different zone, it's a Chapter 10 zone district, that we would just potentially not allow that use in that Chapter 10 RC zoning district, but that would be, again, a legal issue that I don't know.
Yeah, it may depend on the sort of magnitude of what you want to do with the regulation. If you're seeking to prohibit it entirely within this urbanizable zone, I think that starts to look a lot more like this moratorium that you have to have a vote to do. What you're talking about is prohibiting it within 1,000 feet of the city limits where the city has adopted the prohibition. That starts to make a little more sense. It may be arguable that it gets closer than maybe allowed.
Well, the city of Eugene in the near future is likely to have urban reserve. How does that apply?
It would be under the county jurisdiction.
Yeah, until it's, according to the statute, it's talking about area within that entity's jurisdiction, which in the city is the city limits, and so it's just until you annex in.
Urban reserve is...
Yeah.
I have a kind of a process question. What are other counties, maybe our size or with comparable dimensions, like Marion County and Clackamas County? What are they doing?
Well, it's a moving target. I've been trying to track it. Everybody's doing it a little differently. I haven't specifically looked at Marion County. I have been trying to track some of what Clackamas County is doing in Washington County.
Seems like there's some economy of scale here where, given the technology, we could maybe have a joint meeting with those two counties, have a little discussion of because I'm sure the lawyers and planners, land use planners are trying to get us up to speed on this as they can. And from a policy standpoint, I could see where something like the charcoal filter thing might be appropriate in a processing facility in a residential zone. But I'm not too knowledgeable about whether that's an issue in the growing side of things. Is it all indoors, or is it outdoors and indoors? Or
It doesn't specify if it's outdoors or indoors.
for the growing?
Correct.
Is that commercial? Is that what's going on in other places where it's grown commercially? It's both in and out?
Talking about other states?
Yeah.
Yeah, correct. And as an example, Southern Oregon Metro area is predominantly going to be outdoor operations. It's probably not year-round, so to make it year-round, we would go indoors. Up here, it would be primarily indoors. Outdoor season, I don't think is on there.
Okay. So, what do you think of the idea of having a bigger discussion of this as appropriate? Do you see any value in that, or do you think that we're all going to just kind of go our own way?
My sense is everybody's at a different step, and it would be difficult to get all at the same point where you could have a valuable discussion, but we should reach out. We are reaching out. Ken's reaching out even this Friday, and I was, a month ago, was meeting with all the other county planning directors around the state, trying to figure out who's doing what examples of things you have. So we're actively participating kind of in that ongoing conversation. It's just like I said, we're all at different points. We're a little behind some counties, we're way ahead of some
Are
others.
there deadlines? What if we did nothing?
Well, then again, I would point you to this attachment C. This is how we would see if we did nothing, we would implement it today. There are no deadlines, other than OLCC is going to start taking applications for the licenses after the first year, and it's anticipated that by the fall of next year, they'll be actually issuing the licenses. So whatever we have in place at the time those the land use compatibility statements start coming in that front door for us to sign off on, then that's how we'll be signing off on it.
Could we prohibit the growing in forest zones, for example?
I think it would be, one of those time, place, and manner regulations, whether it passed the test of being reasonable, which isn't defined, whether we want to outright prohibit it in a certain zone. I think it's something that can be tried.
That's the reason, you got to measure what the reasonableness of the regulation is. If the law allows the use of the road, I think you have a hard time prohibiting it across the entire zone, especially forest zone where farm uses are allowed out there.
Other farm uses are allowed, so therefore probably would breach the reasonableness threshold. Okay. Do you have any specific examples of the manner regulations, like the charcoal filters, that end up being a de facto prohibition? Like requiring all marijuana growers to have filters where it might be, I don't know, but it might be that really it's the processing that creates the potential for conflict.
So I've been reading the minutes from the committee meetings that they're making recommendations for administrative rules, how to implement this. And on those committees are a lot of representatives from the industry. And a lot of the feedback from those industry representatives are feedback in regard to what you're asking about in terms of these would basically prohibit us from operating them. So one I can just think of off the top of my head is requiring on-site physical presence of somebody being on-site 24 hours a day, or on-site security, for instance. They want the option of having electronic security rather than having a physical person there for 24-hour security. So at one point they were considering the recommendation for a rule that for certain licensed type facilities, they have a person there 24 hours a day, and I said, no, that would prohibit us from operating in that. We should be able to do electronic surveillance and security instead. So that was just one off the top of my head.
Just an example where if the industry was able to show that would be a unreasonable requirement really intended to stop the growing.
Commissioner Stewart?
Thank you. Well, I appreciate some of the work you've done on this so far, and I guess some of my thought process and feedback to you is some of the communications I've had from constituents up to date that have been impacted by odors. So I was approached by an individual who lived in the Stevie Loop area that rented a duplex. One side of the duplex, folks had a greenhouse and was growing in the greenhouse, and then bring it into their garage to store it. I don't know if they did any processing there, but then the entire house had this odor to it. Not smoke or anything, but odor from the plant. The odor, this individual couldn't even enjoy her backyard because the odor from the greenhouse came over. So I'm envisioning in my mind that that's a pretty tight quarter. So when you talk about some of the uses, I'm questioning whether we want to entertain potentially rural residential anything under 5 acres. So I think 5 acres might be able to put some reasonable setbacks in there to possibly have some level of separation, a chance that those impacts won't be dealt with. Like maybe you have a 5-acre parcel and you limit it to a half-acre or less that's used in the production of the product. Growing, I guess, is kind of a thought. Hours of operations. I think there should be some hours of operations when you're talking about rural residential, because as I hear the citizens talk about other items that are impactful, whether you're a rock fit or you're, hairdresser or whatever you are operating in rural residential areas, I think people would appreciate having some reasonable hours, maybe, I don't know if you could limit trips, but at least hours of operation. When you talk about security, I think security is important, and as I think of a product like this similar to alcohol, the local beer pub and Pride Grill had to put cyclone fencing around their production facilities. So does it seem reasonable that there should be some level of security around this product because it is a product that's like alcohol and other products? It seems to me like it would be reasonable to have some fencing requirement or something that offered some level of security over and above just an open field where you can walk into it. Charcoal filters, that's interesting. That's the first I've heard of it, but that might be some way to deal with some of the odors. Case in point, the bowling alley in Cottage Grove has a medical marijuana facility right on an adjacent wall. And early on in the process, we learned that they couldn't process their product inside their building on hot days because it would exhaust their building and come in the intake air into the bowling alley and saturate the bowling alley with the odor. So for me, that kind of thinks should there be some sort of level of separation. When we're talking about commercial, should there be some distance between other businesses, so maybe that wouldn't immediately impact every business. As far as being to monitor, coming and going from the business, hardly ever, experience just an occasional, individual purchasing the product, so I don't see conflicts in that situation. I see 1,000 feet from schools is good. The question is 1,000 feet from other facilities. I mean, we don't require Safeway that is located 1,000 feet away from Price Chopper or Market of Choice or whatever, so I question what is the reason for having a 1,000-foot setback. And, you know, I see it in Cottage Grove specifically because I live there. We have 4, I think, a soon-to-be 5th facility, medical marijuana facility. They're down to 10,000. And, yeah, they're 1,000 feet apart, and it's really like, okay, what's the purpose of that? And I'd have to understand what's the thought process behind putting some sort of limitation on distance other than schools, kids, parks, and things that might be similar to the back of
Throw out, at least my thought on it, it's similar to the prohibitions on having to strip clubs too close to one another, actually. You don't want to create this bad element in business all in the same area.
Do they have that same rule for taverns and bars?
Well, no, that's what I'm saying. Whether it makes sense here is anybody's guess. Whether it makes any sense in any realm is, up to the person. But I assume that's where this idea of keeping them separate comes from. Historically, that's been done with, let's say, strip clubs and adult bookstores and taverns.
It is a dispersal proposal as opposed to clustering, and it kind of cuts both ways. Maybe you want to have them clustered in a certain area of the county or whatever, as opposed to being dispersed. That's a policy call.
I don't know that I wanted to. It might be their choice.
That's what it is. We changed the name to Pie Lanes.
Yeah, those are kind of my off the cuff, and I appreciate it. So I think we should be thinking about reasonable requirements ahead of it, and instead of there's nothing I think worse than being reactive to a situation after the fact.
You're going to have that grandfather. Keep in mind that whatever you delay reacting, you can't go backwards.
I'm generally opposed to just arbitrary rules, whether they are arbitrary or seem arbitrary, to people observing from the outside. And some of it seems, when we're talking about doing something for the very first time, it smacks of arbitrary in nature. I mean, looking at keeping establishments 1,000 feet apart, well, does that mean Dairy Mart and 7-Eleven can't be slightly feet because they both sell beer? If we want to distill beers, I think it becomes kind of arbitrary. Bearing that in mind, recently I've had a chance to listen to and talk to retailers and wholesalers from Colorado who retail marijuana and wholesaler. And it's amazing how in the period of time that they've been able to do it, they've become pretty sophisticated. They've addressed a lot of the issues and they've found ways to address concerns and seem far less arbitrary in the way they operate on the retail and the wholesale side. So my point there is, when we kept building Jerry's stores, and we never did anything new, we always saw what other people were doing first. So we have Colorado as an example. And we're talking about looking at other counties in Oregon and realizing that Colorado's land use rules are significantly different to ours. Wouldn't it be possible to take a look at Arapahoe County or Grand County and see what they're doing in and around Denver and particularly maybe around the town of Boulder, which is not unlike Eugene. I think that's Boulder County. And, see what they're doing. Because I think, listening to the way the retailers do, they hire experts. The retailers hire experts to address their concerns. The wholesalers have hired experts to address the concerns that those of us have regarding the distribution of marijuana. We don't want people under 18 to get a hold of it. We don't want it going out the back door. And the various things that really come into mind. And some of the things we just simply don't know. I mean, it's brand new in Oregon. And even if you look at what Washington County is doing, or what Jackson County is doing, we're probably going to be leading the way in that county. We tend to do that and to think of things because of the nature of the population. We think of things pretty early in the cycle. So, Commissioner Sorensen suggested having a joint meeting with Benton County. But I think we should have a joint meeting in Breckenridge with Eagle County. And we could do it next week, as a matter of fact.
I didn't want to have a joint meeting at all.
So, but seriously, when we look at what's happening in Colorado, they've been doing it for a while. They've experienced some ups and downs. They've made mistakes. And based upon my experience with what's happening on the distribution side of things in Colorado, they've been thinking about it, and they've been doing things, they've been addressing the major concerns.
Thank you. So, I think through this whole thing, so I'm kind of getting there with the land use snapshot. The one thing that's different about Oregon than Washington, Colorado is OLCC. I'm still trying to figure this one out. How in the world are they going to regulate this? Because frankly, I think they're getting ready to open the door, if they're not careful, that hard alcohol will be sold to grocers and privately, because what are they going to do? Set up specific shops that sell marijuana only, like we do with hard alcohol? I mean, I'm trying to figure this one out, because that is such a huge difference between Washington and Colorado compared to Oregon. They don't have an OLCC. You can just walk into your grocer and buy your hard alcohol. So I think it makes it easier from the retail side. And so this is the one that confuses me as much as anything. So as the rules are being written, I'll be real curious how they can figure this one out, because I just don't see how it's possible. Hard alcohol, they have a system set up. Okay, I get that. We all go, if we're going to go get whatever the case is. I mean, we just got back from California. I'm walking at Safeway. I even took pictures of it, There's a beef eater right here in Safeway. It's about the same price as eggs, which just blows me away,
It's cheaper at Costco.
No, it's cheap. And, that one retail place for hard alcohol right down there close to the California border, it's huge. Buy your gas and buy your liquor. And it's all for Oregonians to cross the borders and buy their hard alcohol cheap. But, so that's the part that I'm really grappling with as much as anything. As far as the land use, I think what's important is to make sure that we have certain abilities in place on how we can make sure it's regulated. After listening to because when you talk about the indoor and outdoor growers, I thought the argument was only between marijuana growers and hemp growers. It turns out there's a significant argument going on between outdoor and indoor. Hey, whose is the pure and whose is the right and whose is the better? And then, of course, you bring the whole hemp issue in. And I thought it was interesting. The Senate said, we'll pass. And so Josephine County says, well, okay, fine. We'll continue to grow lots of hemp down in Southern Oregon then, too. And we know what it does to marijuana. And so it causes some issues.
We're not even talking about GMOs yet.
Well, so I think what's important is from a local government standpoint that we have some abilities here on how to regulate from the growing standpoint. On the retail side, like I said, I think that having OLCC and having how this is going to be regulated from that standpoint, I think it's going to turn out to be such a mess. And again, it's based on the fact that you can't say that we're going to, from a retail standpoint, distribute or regulate this the same as Colorado and Washington, because that's not in place. And it's a whole different rule. In fact, I would say the apples to apples is Colorado and Washington. And all of a sudden, we're not even a fruit. I guess we're an onion. And because of how different it will be from that standpoint. But that's really the only thing I can think of. I appreciate Commissioner Stewart's comments, because I think what I was just listening to him was almost like a shotgun, just constantly going and bringing up some thoughts and ideas here, because this is new. But at the same time, from our perspective, we should have some abilities to regulate on how, who gets to do what, where they're gonna grow it, where specifically what's gonna be located in. I mean, that in itself will be pretty interesting as we move forward, but, on the retail side, I have no advice for OLCC at all. I just don't even, I can't even figure out how they're gonna do that, so that's just my thoughts on it. Appreciate the work, I mean, because this is new too. I mean, this is new. You're thrown on your lap, and I'm not going to make any more jokes. So maybe we will end on a high note, Mark. So
I'm going to bring us back more serious. My first thing I have is a question, and in your presentation, going way back to like the second or third slide, under personal growth, it basically says it's not a land use issue, and it won't be regulated by zoning ordinance at all. And then you have a following slide that talks about how it's going to be treated as an agricultural practice and protected under the right to farm protections. And what I'm getting at here is there's been a significant amount of complaints, and Commissioner Stewart's example of the duplex is typical, and I've had them in even the Santa Clara area with a neighbor that was growing medical in their backyard, and the backdoor neighbor to them was having extreme problems with the odor because they had their greenhouse up against their back fence. Is there any way for us to at least have nuisance ordinances relative to odor for personal grow? Are we allowed to do anything relative to personal grow and nuisance ordinance?
Can I just ask a question, Andy? Wasn't there a ruling recently from the court that said that the odor from marijuana is not offensive?
It's usually the fertilizers they're using for the marijuana that have the odors, but that's why it's the grow operations.
I don't know.
I thought I saw something.
I'll take a look. Yeah, it's the high nitrogen fertilizers.
I mean, just on a personal note, in college I worked in the greenhouses at Oregon State University, and they had whole greenhouses full of tomatoes. And you get a whole greenhouse full of tomatoes and you stink just as bad, and they use fertilizer. I mean, so it's hard to discriminate against marijuana versus somebody growing tomatoes.
Yeah, it would be mostly an ordinance over offensive odors or something like that. I don't know if we could specifically make it for marijuana grow, something that would help maybe control some of those issues.
We have a hard enough time measuring noise, being noise experts out on Barbara Drive.
And our one compliance officer for the entire county.
I'm not sure how we're going to measure it over there.
Yeah, that's a difficult one.
I just was going to interject here that in Mr. Ruff's presentation, he mentioned that the marijuana industry is entitled to all the protections of the Oregon Right to Farm and Forest Act, which does prohibit victims of pesticide or fertilizer or other intrusions onto their property. It does prohibit them from suing the perpetrator, alleged, and Oregon Court of Appeals has upheld it even in the situation of a timber company, the plaintiff, suing being sued by a commercial winery, and awarded all costs and fees to the alleged perpetrator against the winery that was the victim. And so it's a very strong law that's been upheld at least twice that I'm aware of in Oregon. So I just don't see that as being an area that the county could move in. There might even be an
That's
absolute
why I asked the
prohibition.
question, does a personal grow operation also cover it? I know that the commercial grow operations will be covered under the Right to Farm Act. Is a personal grow covered under that?
And personal grow is 4 plants. You could probably do it in the closet of the bedroom, I'm not sure if you can get a greenhouse, but, anyway, I don't know how much smell or other impacts are going to come from 4 plants if they're doing it legally under that personal grow exemption.
And then I just want to clarify, you gave us your attachment C, and a lot of the medical is allowed in places where we're prohibited for recreational, et cetera. Do we have any ability to do time, place, and manner on medical at this point?
So there is, under the new House bill, it does modify the medical marijuana growing abilities. I'm not sure they leave that as wide open for local jurisdictions to regulate as they do the recreational components. I can sure look at that. And I can just tell you from listening to the attorneys for the Association of Oregon Counties, they intentionally wrote a lot of this regulation to incentivize people moving from medical to recreational and basically have the medical marijuana industry go away and have it all become recreational. The fee structure is incentivized that way, the regulations. So for whatever that's worth, he said that he expects the medical marijuana dispensaries to all convert to recreational. It'll be anybody can buy it anywhere kind of thing.
That's somewhat my expectation too. So, getting down to the idea of what time, place, and manner restrictions I'd like us to continue to investigate. I'm of the side, somewhat like Commissioner Farr. We don't know what the real issues are going to be yet. And keeping a light touch on not being preemptive and trying to restrict the problem we don't really know exists. Like, we don't know if there's going to be major odor issues or not. But with that, my real concern is the RR zone, and allowing commercial operations into an RR zone just because they're qualified as an ag practice. We have restrictions in our current zoning code about number of birds per acre you're allowed to have as far as having chickens on your property, for just the reason we recognize it's a residential zone. You might be able to do some home farming, but the idea is you're not supposed to have a commercial, chicken production facility in the middle of a bunch of residential neighborhoods. So we limit the number of birds per acre you're allowed to have. We limit the number of horses you can have on an acre. All that's meant to, you are rural as part of the zone. You're rural residential, but my area, a lot of the rural residential were parcels created prior to the zoning code. It's zoned RR10, but I'm on an acre lot. My neighbor's an acre and a half. A lot of the parcels are far smaller than 5 acres. And my concern is now we've got something that, like, one of the reasons they don't have the dwelling in the EFU zone is you can make $80,000 in a 10 by 10 building a year. So you're bringing a commercial, could be a several $100,000 a year enterprise into a rural residential zone. And that was not really the intent of rural residential zoning under the statewide goals. They're meant to provide, to allow for housing in the rural areas, not commercial operations. So I would look to, maybe making it easier in the rural industrial zone, than our current code, actually loosening our code in rural industrial to allow for grow operations, but making it, nearly prohibitive to put it in a rural residential zone, either whether it's 100-foot setbacks from property lines, so it kind of almost requires a 5-acre parcel. That's where I would focus, loosening rural industrial, because we've got abandoned bills along the Siuslaw River that could, have 10,000 square foot buildings that could be available to turn into a grow operation. Lots of outdoor log yard land could be made into a grow operation with no neighbors around them to impact. on a major highway, and already have large amount of power coming into the property because it's a former mill, I would rather see them locate there than locate somewhere, halfway between Triangle Lake and Junction City on 36 and some rural residential property where some old partitions were done long before Senate Bill 100 passed, and you got a bunch of 1-acre lots all around each other, and one person in that area decides they're going to commercialize the grow operation, and we end up with a lot of complaints, and we end up with a commercial operation in a residential zone. So that's really where I would focus time, place, and manner, about that. And try and see if there's the ability to extend that into the medical side, because right now it's all out, more or less, except for the actual dispensaries, which is surprising under the recreational would be allowed as a home occupation. To have a recreation, and I've got a home occupation for my property right now. So I can just imagine I'll convert that home occupation to a retail marijuana outlet and do a grow in some of my other buildings or something like that, and I'd start having a major, business in the middle of a residential zone on a gravel road. It's behind the high school, but I don't think I'd quite make the 1,000 feet from the school, so.
Sounds like you put a lot of planning into it.
No, I guess I didn't plan it out too well. My property's too close to the high school. But, you know what I'm saying? That's where I would concentrate my focus. I'm not that concerned about the EFU or the F2 zone or the F1 zones. I'm not concerned about, in fact, I would actually move them to rural industrial zone descriptions. Except, and I think the rural commercial, there we're looking more for, that's where we want the retail establishments to be, not the grows necessarily, because there's a very limited amount of rural commercial stock in the county. But that's kind of, and right touch with the exception of I really don't want businesses in residential zones. There's a reason why we chose to make that land available for dwellings and needed housing, and we don't really want it to be commercial. Commissioner Clark.
Thanks. I still contend we're shooting in the dark on this. We don't know. You're looking at the value of the plant, and I just looked it up here. That plant is valued anywhere from $2,000 to $5,000. That's a $4,000 estimate on that. To grow $80,000 worth of marijuana, it says you need about 1 square foot per plant. Do the math. In your closet, you can grow $80,000 worth of marijuana. According to those numbers. So, whatever. I'm just quoting. But, we don't know. To presume that we can in some way regulate it, if we over-regulate into the whole bird, then that, pushes people more into the covert, and the only way you can really tell what we're doing is by measuring the electricity use, perhaps. So it's, to me, whatever we do now, we're going to look at it again in the year and say, whoa, wish we would have done it that way. So I think we at least need to look at what's happening in the United States, even though regulations are very different, and just to see what kind of obstacles they've run into. The Arapahoe County Sheriff's Department, what do they see happening as far as distribution, growing, and retail, wholesaling, and growing, and just kind of get a feel for what sort of obstacles that they run into. And if they do try to regulate it, where have they had to change regulations because they're regulating something they didn't know how to regulate? You're regulating free oxygen. How do you do it? So,
Understood.
Thanks, Mr. Chair. Commissioner Carr, I agree with you. I think the things that I've placed out here were actual physical things that I've worked with in my office since I've been a commissioner. So I know that there's going to be issues that I just throw out here that we should be contemplating. I'm sure that I'm probably missing a lot of other things because I don't have any knowledge of it, but the incident with the rental, that was a true situation that had to be dealt with. The other situation is our owner in bowling alley that has a medical marijuana building right next to it. I know what the challenges are there, and I think that we should at least be understanding and considerate of those and see if they need to be addressed or they don't need to be addressed. But those are some things that, I think we should spend some time on.
And I think your list is absolutely valid based on your experience, but then how does that list apply to what's already been looked at in other places?
Mr. Chair, so one of the things it's just thinking and more than anything else, because I think Pat has said it correctly. I don't even know what to expect here. I mean, so we've had the medical marijuana places set up now for a little bit of time, and so we have kind of an understanding of that. But it's this full grower side that becomes different. And the fact is, I mean, from your perspective, being in the land use, the planning side, I just kind of like to get your opinion, understanding that you're getting ready to help cite a business here, knowing that it is a cash crop. There's no financial regulations here on this business whatsoever. And also you enter in the public safety aspect of it, knowing that it is a cash crop, and you don't have the ability to take your money to the bank for deposits. I guess from I'd just like to get your opinions on this, because this is, to me, again, this is where it opens up some different areas, different avenues, and just from that land use planning side, what are you thinking, knowing that this is a cash crop that does not have the ability to take its income to any sort of financial institution for deposit and have that protection. So, you know what, I'm not asking for any sort of, well, here's what land use, I'm just your opinions more than anything, because I think Pat stated it perfectly. We don't know what we're really getting ourselves into here. So, just get your thoughts.
So, I'll speak to something Commissioner Bozievich said, and I agree that focusing on the rural residential zone is probably a good area to really focus on. It's where there's the highest potential for there to be greater impact. So I think trying to regulate the farm and forest zones is definitely a light touch, if any touch there. I actually have some personal experience. I have a brother-in-law that operates this type of business down in San Francisco Bay Area for medical marijuana delivery. They have a whole fleet of armored vehicles that they drive around and follow the little delivery vehicles. And they have rooms full of cash that they have nothing to do with, and they're trying to figure out how to spend it. Or if they're going to start burning their probably something. But it's for him been an interesting experience. He kind of got into it by accident. It's been a big eye-opener. But you're right, it's a cash crop that they can't take the money to the bank. And so I think some of these security-type issues become a real concern based on some of that at some point, whether it's the cash itself or the product itself. So for me, it's the growing aspect, whether in farm and forest isn't really maybe an issue. It might be the retail outlets being focused in the RC zone, trying to steer those there. The processing type uses, focusing those more in the rural industrial zones and some of the indoor grow operations in the rural industrial. So I think it's really just doing some massaging of our regulations to steer some things in the right directions to minimize the impacts to communities. Again, primarily the rural residential communities. I think that's where I think there's the greatest potential for negative impacts.
But there's so much nebulous unknown about it. The Washington State Liquor Control Board. They had a liquor control board. They don't have one anymore. It's now the Washington State Liquor and Cannabis Board. So, they had to make that kind of a change in their government. So I think whatever we do, we need to do something. But whatever we do, we better be prepared to change it based upon the moving target we were talking about earlier.
Well, it's now the OLCCC, but it's the Oregon Liquor and Cannabis Control Board.
Is it?
Yeah.
Just as background, medical marijuana, we've treated those dispensaries just like our pharmaceutical use. I mean, we don't distinguish the type of use. That may be one option, is to actually define the certain type of marijuana facilities, whether that's a retail outlet, as a specific type of use, separate from any other general retail type of use, and then allow it or not, for instance, as a home occupation in the rural residential zone. We could say, no, it's not allowed in the rural residential. It is outright permitted in the rural commercial. That steers where we think it might best fit.
Well, if people can raise chickens in their backyard without people knowing about it, how much marijuana can you raise in a room this size and nobody would ever know?
Well, the question will be, is it going to be worthwhile having an underground operation that's not permitted versus competing with illegal operations? That hopefully the whole point of the legalization is to get rid of the underground operations, bring them out in the open, which is one of the reasons why I'm promoting a light touch. Because that's the intent. And, you and I both met with both a building owner and a potential grower for a commercial indoor grow operation. And these are people that are in business already in Colorado and Washington. So you talk about bringing in the experience from Colorado and Washington. They already have it. And I think in the long run what this will shake out to is there's going to be the Philip Morrises and the Budweisers of the marijuana industry that are going to be the large people, and then there's going to be the Ninkasis and the Hot Valleys, where it's going to be the specialty, high-end, small operations.
There he goes again.
It's going to shape out eventually to one or the other, and you don't see you still see people occasionally brew beer in their there's the Alex Tylers of the world that still like to do their own brewing, but it's not typical. It's not something, you can grow tobacco in your backyard, anytime you want to. Who wants to go through the growing and curing and then the cutting and sorting and processing of tobacco when they can still just go buy a carton of cigarettes somewhere? That's the whole, not too many people make vodka from potato skins,
But this is so different. I mean, you can go marijuana in your third bathroom.
Yeah, it's the same thing. But it's going to be eventually, I think, where we'll see people that are professionals at doing it, that can have the quality control, that can promise that it's not, no chemicals were used in the process of making it. That all sorts of various things that you're going to see the commercial industry step in and the free market shake out. My only concern at this time right now is, the time, place, and manner restrictions necessary to prevent commercial operations from operating in a residential zone, and steering them to the commercial zones where they should be and industrial zones where they should be, and the ag practices to the agricultural zones where they should be, and doing it with a light touch. And I think, making some definitions that steer in that way a little bit better. I am not pleased with where it would be if we do nothing. If we do nothing, we're setting ourselves up for having commercial grow operations grandfathered into a rural residential zone when we realize it's a problem later. But somebody's already established one, so we can't do a retroactive operation on that. I think it would be a mistake for us not to be a little bit preemptive with that part of our time, place, and manner restrictions, to try and get commercial activities in the commercial zone, residential activities stay in the residential zone, ag practices in the ag zones. I think it's a smart thing to steer them in those directions.
I guess what's the board's preference about what form you want to see this in next?
Analyze the issues and come back?
I kind of leave that up to staff to give us the best options to maybe achieve those goals that were, although I'd like to hear the rest of the board, at least my concern, which is to steer the activities into the correct zone. However, what's the best vehicle for doing so, whether it's in how we define it or just outright descriptions in our zoning code for each one of those zones, what's allowed and not allowed. I'd leave that up to staff to make the best recommendation.
And I think we can put together some ideas and thoughts. At some point, any code changes would go through the public hearing process, starting with the planning commission. But before that, I think I've heard overwhelmingly today that yes, pursue looking at some reasonable regulations. So we'll do that. And then bring kind of a spectrum or some ideas and or a menu of ideas back to you for then the direction to pursue down the public hearing process and see how those ideas come out through the public hearing process, ultimately then back to the board at a hearing process again as well. Is that?
Yeah, that's why I wanted to make sure that you wanted to have another look before it goes into this code development process.
I think that's a good idea.
Yeah, I think so too.
I'll just ask that you also send us email or otherwise keep us informed of things like Coburg or other communities that are making decisions that will affect us. And are there any other cities besides Coburg?
Crestwell, Junction City, Coburg.
They're all going to their voters with no growing, no selling in their cities.
Junction City are going to the voters, Coburg outright.
Oh, they did outright.
Yeah.
What is your investment about?
Sure. And on the OLCC website, I could send you a link to that. They have compiled a list of all the jurisdictions of counties and cities throughout the state that have referred something to their voters or prohibited it outright.
Does that affect the amount of money we get from the state?
The more that prohibited, then the more money we would get if we don't prohibit it, is my understanding. Because those jurisdictions that prohibited then give up their piece of that pie.
Okay.
Thank you.
Thank you. Wow. So, move assignments.
Mr. Chair, the only one that I had was the request to discuss the status of Trillium under its new umbrella ownership, and so we're prepared to do that as part of the trip next week, and I was thinking maybe a 10-minute update for it. What I would ask Commissioner Lycan in particular is if you'd like us to invite Terry Copeland, we can do that. What I was hearing was just sort of an update from staff.
I'm more interested in an update from staff at this point in time, and just to kind of keep us clued in on what's happening.
If it requires more discussion at a later date, you can ask next week that we schedule some future time for Mr. Copeland to come. But that was our thought, is we'll just do a 5-minute update from staff and answer questions in email. Okay. That's the only thing I have.
I'll just add on the discussion about Trillium and the whole medical and hospital picture and the relationship of all that to Lane County government. I think that the idea of having this work session, in my mind, we should have that work session separate from the one that's coming up. In other words, it's okay to have it in addition to that, but my idea is that this is actually, from my conversations with the medical community, the doctors I've talked to about this, is that this is a very big thing, and or at least they fear it's a very big thing, and that we, in our role with the coordinated care role we have, we need to really get on top of this. So I think it's great to have the update from staff on next Tuesday. Yeah,
Doing a work session on a shift. So it's
on the children's health. Community health
program.
Yeah.
And so our thought was we would have a brief discussion on the update on this.
Yeah, I think that's a great idea, but what I'm saying is I think we need to get ready for a bigger discussion. And I think that the community, through various means, is contacting us about this issue. And also at the summer meeting, Sid and Pat and I all went to the summer AOC meeting, but that was brought up there by the commissioner from Deschutes County. Baney?
Yeah, Baney.
What's her first? Tammy Baney. Tammy Baney brought this up at the summer AOC meeting, so we might want to even get AOC roped into this, because they know quite a bit about it, too. And it's becoming an issue, she said, because of the private ownership of these coordinated community care organizations.
So, just briefly, Mr. Chair, what I would say, the purpose of having this work session on the Community Health Improvement Program next week is to make sure that going forward, we've done a lot in the last year. We had many discussions on tobacco, and, my part, I really want to make sure going forward that we're clear about the board's priorities, what the board has established as part of the CHIP, for us to be, for staff to be presenting and bringing forward to you. So that's the point of this work session next week, is for our staff to get clear with direction from the board on what you want us working on, so there are no surprises, okay? So we don't have to, in my opinion, repeat some of the things that maybe could have gone a little bit smoother, I think, in some of these discussions over the past year. So as it relates to this discussion about Trillium, I think it fits well as we're re-looking at what the board's priorities are with the CHIP and the goals in the CHIP that you want us to bring forward in the next year. If this is a discussion that you want to focus on beyond just a 5 or 10 minute update, and you'd like to broaden that or establish some particular goals related to it, I think next week is a good time to give us that direction. So
I think it's important. I don't think anybody really fully understands the CCO concept that we have in Oregon. There are 16 CCOs in Oregon. They're all very different. There are some similar models between different areas. We just happen to have an area. Lane County is one of the areas, one of the 16 areas. And so I think the discussion of how we contract with our CCOs and how other counties contract, groups of counties contract with their CCOs, I think we're going to really understand how that happens. It's a concept that we use in Oregon that isn't really used anyplace else, and it's innovative, and at many levels it works, but it works for different reasons in different CCOs, and so it'd be interesting to see why and how each of the CCOs works, and who owns each of the CCOs, and what is the county commission or the group of county commissioners roles in managing and contracting with the CCOs, because I don't think very many people know anything about it, other than the state health department and everybody who's been closely associated with the state health department.
Mr. Michael?
So, thank you, Mr. Chair. So to get back to Pete's point, I think the reason why I'm comfortable with an update now is because the timing. This is going to happen now. It's not to preclude that, in a sense, I think what we're doing is setting the table to have a little bit broader discussion so we can bring Terry Coker in and have a little bit more of a conversation about is the delivery service changing? I mean, what kind of changes are happening, if any, within the Trillium family here locally? How much will this Trillium have the ability to set its own, in a sense, its own community policy without having a major corporation breathing down its neck? So the update, I think, is perfect because it's happening now, and then it allows us then to maybe move forward on a broader discussion, a few weeks from now. So I think that the timing's right, and that's why I think having that 10-minute update is really I just want to say thank you for even, making sure that we can have this, because I think it's important. But then we can maybe potentially have that broader conversation in the future, because I think Pete's right. I mean, Mr. Baney, they're sounding a couple alarms over in Deschutes County. In fact, so at this point in time, they have a nonprofit as their deliver services. and she's now having to fill that role as an interim executive director on top of being a commissioner, on top of Oregon Transportation Commission. So, she's a pretty busy person right now, but there was an alarm sounded from, on what's going on in Deschutes County, so it is important to stay on top of it, so I appreciate it.
And it's interesting because we have what seems similar when Triad acquired McKinsey & Wyman.
Yeah.
A large national corporation acquired a local organization. But just as face value with similarities, that's the only place that similarities happen to be. So it'll be interesting to know. I think a lot of people see what happened with McKinsey & Wyman and say, whoa, wait a second. All of a sudden it was a different place. And they feel that the same thing is going to happen with a locally owned a cooperative, basically, what Oregon had then. So it's, it's important that we know what it means that, and it's important that as many people in the public know what it is that's happening, rather than what's happening now is people speculating on what might be happening.
And I guess I'd like to add to the conversation, it's really about trust and transparency. And right now, there's a lot of questions that are out there. And, the providers that I've talked to in the local community, they're concerned about who's our voice. How do we find this information out? They felt fairly comfortable with Trillium because they felt they had some transparency and some ability to communicate their concerns. They're just nervous about the process ahead. So I think it's really good to follow it. The other question is, I really believe that this was the direction of our former governor that kind of laid this out as, trying to change the way healthcare provision is. It's going to be interesting to see where Governor Brown is going to take this, or continue on the same path. And I think that, the other question that comes to mind is that people here, when there's these huge profits, and, Trillium was sold for millions and millions of dollars, okay, well, where's that money coming from, and who's, is that coming out of care provision? It could be going people. So I think it's really important for us because we are that connection, that link, and we have such a huge role of health provision in our community that we need to step up and kind of bring that transparency and that trust component to it and kind of lead on it to make sure that the people believe in the system that we have here. And if it's not working, we need to step up, and I think we need to do the best we can to fix it.
The timing is good, and I think you're absolutely right that there is a need for greater transparency and communication on the issue. Because what we've been told by petroleum executives is that there really is no change. They were owned by, Trillium had been owned by a parent company, Agate, and now they're owned by a parent company, Centene. And Trillium still exists. That structure existed before. There's a different parent company today, but the local board and the structure of the CCO and the relationship with the county, nothing is intended to change. And we continue to hum along, right? Because we're planning to open a new clinic. We're opening a brand new clinic in the next month, and by the end of October, that they help pay $1 million towards. So we see that commitment and that relationship and the local investment continue to happen. I think the board needs to hear that. It needs to be on the public record, and there needs to be better communication about this because there are a lot of perceptions and misperceptions out there.
Just as I said in the board meeting to Alicia earlier, change always brings about apprehension and stress. And if we can, the way you fight that and relieve that apprehension and stress is with information. So having it in an open board meeting, I think, is important. So any other assignments? And we've already had our exec session. Any other business for the board today? Seeing none, I will adjourn the board meeting. I'll see everybody at 9 o'clock tomorrow morning for the work session.